The Rust case is done, but not over. We're going to be talking about the judge's written ruling in the Baldwin dismissal. Yes, the judge made a very thorough ruling from the bench, but the judge also memorialized that ruling in writing, and we are going to go through and see what she has to say. In the supplemental report that the defense never got, it lines out that there are 3 Starline brass 45 Colt with silver color primers, brass color casing. Kari Morrissey argued to the court that this has no evidentiary value. Quote, "That is not the same ammunition. You can tell from looking at it. This isn't a Starline brass casing, and it also has brass primers, not silver primers." Kari argues to the court dead. They are obviously different. And the report says that they are, in fact, Starline brass with a silver primer. Further, the court asked Poppell to identify the Teskey supplied ammo that fit this description. The court visually inspected the ammo. Yeah, the court got off the bench, put on the gloves, and looked at it. Thereafter, the court asked Poppell, "Do you recognize any of these types of bullets to have been gathered on the Hannah Gutierrez on the Rust set?" Poppell responded, "The Starline brass with silver primer are similar to what was collected on set." Directly contradictory to what was testified to in front of the jury the day before. The second and third witnesses called were Seth Kenney and Hancock. Both the state and defense asked Kenney questions regarding the ammo possessed by Troy Teskey and how some of that ammo was used during cowboy training camp for the production of 1883, and how the remaining ammo from that camp ended up at PDQ. Additionally, some of the defense questions sought to establish a progressive trail to demonstrate the relevancy of the Teskey supplied ammo collected by the sheriffs. Specifically, defense question developed a timeline that A, 45 Colt ammo was once possessed by Troy Teskey. B, some of that ammo was then possessed by Seth Kenney and Thel Reed for use at training camp on 1883. C, Seth Kenney took the leftovers of the live ammo to PDQ. Seth Kenney then gave purported 45 Colt dummy rounds with brass casings and nickel or silver primers to Sarah Zachary on or about October 12, 2021. E, Sarah Zachary then introduced these rounds onto the set of Rust before the October 21st incident. Could the ammo have come from PDQ? The prosecution has said over and over and over again that the only way live rounds got onto set was because Hannah got them from Thel Reed and brought them. But the testimony from Seth Kenney was that ammo from 1883, live rounds from 1883, went back to PDQ, and rounds from PDQ went to Sarah Zachary, went to set. So did the rounds come from Hannah, or did the rounds come from Seth Kenney, from Thel? Such a wild difference from what was shown at Hannah's trial. That the only place these rounds could have come from were from Hannah. That was what the state said. They showed all the pictures of where it came from and how Hannah got them from her dad. But it could have also come from Seth. The reason this is different for Baldwin than it is for Hannah is that Hannah's defense attorney had this information. Hannah's defense attorney chose not to use this in trial with Troy Teskey. So Hannah has a much different argument than Baldwin. But as to Baldwin, part of Baldwin's defense was this is either sabotage or somebody else did it. But either way, the law enforcement just looked at Baldwin with blinders on. And Seth Kenney was never prosecuted. And they said, no live rounds came from Seth Kenney. Baldwin was arguing, yeah, they didn't even search his place till like a month and a half later. So yeah, there was nothing there then. The ammo can that came from 1883 was empty by the time y'all searched for it. And Seth Kenney gave Hancock shit about putting that in the search warrant. So doesn't that all support Baldwin's argument that everyone was laser focused on him and didn't do the rest of their investigation? Very different than the argument to Hannah. But as to Baldwin, oh boy. Dismissal with prejudice is appropriate for several reasons. First, the state repeatedly failed to fulfill its discovery obligations during pretrial litigation of this case. Second, the state's suppression of the Tuskegee supplied ammo and related evidence constitutes willful and deliberate misconduct. Third, Special Prosecutor Morrissey elicited false testimony from CST Poppell on July 11th in the presence of the jury. That is going to have quite a lot of impact down the road. The court got madder over time because the court said this was close to bad faith. The court is now calling it willful and deliberate and said that the special prosecutor elicited false testimony. Fourth, a mistrial in this case would not only be based upon manifest necessity and jeopardy had attached well before information concerning the non-disclosure came to light. Here, a mistrial would be based solely on the state's discovery violations. In this circumstance, a sua sponte declaration of mistrial is improper. And then the court goes through why. The court says lesser sanctions are inappropriate. The court says, I have the power. The state's discovery violations injected a needless, incurable delay into the jury trial. Further, the state elicited false testimony from a state's witness. Dismissal with prejudice pursuant to the court's inherent power is additionally warranted to ensure the integrity of the judicial system and the effective administration of justice. The written order in the Baldwin dismissal is absolutely scathing. And the court not only talks about the late discovery that was rampant in the case, the late discovery of the Tuskegee ammo, but directly states more than once that the court finds that Special Prosecutor Kari Morrissey elicited false testimony from witness Poppell, the crime scene technician, who said that the Tuskegee supplied rounds that they had in evidence under a separate case number did not match anything on the set of Rust. And that was not true. The court gave a very thorough but scathing indictment of the behavior of the Santa Fe Sheriff's Department and Special Prosecutor Morrissey's actions. Erlinda Johnson is mentioned once and briefly in this ruling as trying to remedy some of the discovery issues, and that is it. The impact of Erlinda walking off is seen very much in this court's order, and the reason is more clear. Because the court states for the first time that we're learning about that in that supplemental report buried under another case number, it clearly describes that 3 of the rounds taken by the Sheriff's Department from Tuskegee the day of closing arguments and conviction of Hannah Gutierrez matched ammo that was recovered off the set of Rust. And the court lines out how that ammo went to Seth Kenney and could have gone to Sarah Zachary and ended up on the set of Rust. So it now gives 2 options for how live rounds ended up on the set of Rust. This ruling indicates to me that this judge is absolutely horrified and outraged by what happened here, and noted specifically the prosecution's eliciting of false testimony during trial. And that's part of why the court dismissed the case against Baldwin mid-trial. The reason Erlinda was so mad comes even more into focus with now knowing that that supplemental report was clear as day. Just clear as day. For deep dives into the stories that I covered here, you can find them on my YouTube channel at The Emily D. Baker and The Emily Show podcast. I stream every Tuesday and Thursday. The podcast goes live on Wednesdays. And if you want to stay in the loop with everything I'm doing, receive the fastest notifications out there, and get more Law Nerd community, join me at lawnerdapp.com, our free app for iOS and Android.